Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secret and non-compete law. We've talked a lot on this podcast about protecting trade secrets, but today we will be talking about trying trade secret cases. My name is Kate Rigby, and I'll be your host for this month's episode. I'm an employment attorney and litigator in EBG's Boston office and one of the hosts of Spilling Secrets. I'm joined today by two other panelists. The first is Jim Flynn, managing partner of the firm, trial lawyer, and a returning panelist on the podcast. I'm also joined by Adam Payne, a business and commercial litigator who I've had the pleasure of working with in our Boston office. Jim and Adam, thanks for joining me today.
This is Jim Flynn, and Kate, I'm glad to be part of this discussion. As you indicated, I'm in the Newark, New Jersey office, but I litigate trade secret, restrictive covenant, and other intellectual property matters, as well as some regulatory things around the country, and frequently get involved in trade secret and restrictive covenant matters, even beyond the preliminary injunction and TRO stage. And so I actually have tried trade secret and restrictive covenant things to juries or to judges, and look forward to discussing that.
Hi, Kate. Hi, Jim. This is Adam Payne in EBG's Boston office. I'm an associate in the commercial litigation group. I have experience litigating a wide variety of commercial and business torts, breach of contract claims, restrictive covenant cases, and employment litigation.
Great. Well, I'm so glad that you both joined me today. In past episodes, we've talked a lot about, many issues that arise when litigating trade secret and restrictive covenant cases, both during and after the injunction phase. But today we're going to focus on issues that arise when trying a trade secret case. And among other things, with any trade secret case, you'll need to identify the trade secret or trade secrets. And if you're the plaintiff in the case, demonstrate misappropriation by the defendant, and then prove economic value of those trade secrets. And so we're going to discuss each of those and some other issues that can arise during these trials. So to start us off, let's discuss the strategic decision of whether to try the case before a jury or a judge. What are you all take into consideration when making that decision in these types of cases?
Obviously, you're going to take into account which party you are. Are you the plaintiff or the defendant? And that'll have certain implications for you. You're also going to take into account the level of damages that are potentially available, or whether this is really a case about making preliminary injunctive relief permanent. And you're going to try to figure those things out and figure out who's going to be the best audience for the legal issues and who's going to be the best audience for an explanation of your trade secret, how you're going to present it. So those are the kind of core issues that I'm focused on at the beginning in making that choice. And, I'd be interested in Adam's comments, and then we can kind of figure out which parts of those choices push you in each direction.
I think one of the key factors is the types of facts or evidence you might have at the outset, and whether you have a particularly compelling story to put on for the jury. If you have personal disputes and clandestine activities that would tell a compelling story for a jury and really grab their attention, that might sway your decision to put on your case for the jury. If it's a bit more dry subject matter and the evidence and story isn't as compelling, might be better to put on for a judge.
Do look at the type of the judge that you have, for example, right? Because sometimes when you're filing these, most of the time, a lot of times you're filing these maybe in federal court, so you don't know right away, but then you get your judge. So do you, when you're starting with the injunction phase, and so what do you take into account when you know in federal court, for example, who your judge will be? Is that something that you would look at?
Sure. I'd be looking at that, right off the bat. I might even be looking at that before I file, and depending, on how I file and what I can learn from the clerk's office, if I know that a particular judge is going to be assigned to emergent duty, or some small select group has emergent duty on a particular day, that might influence me as to whether I file on Tuesday or Wednesday. That's a little bit inside baseball, but sure, I'd be making that decision. I'd be contrasting being in the local federal vicinage with, okay, if I do this in state court, as I do in New Jersey, you might be in the Chancery Division if you're looking for predominantly equitable relief, so you'd be making that choice between state Chancery Division, federal court, district court judges, and some sense of who might get that case off the wheel. Those will always be important considerations. And obviously past experience, if you know and have a good sense because you've been before judges on those initial applications or tried cases before those judges, that all goes into the mix.
Right. Yeah, that makes a lot of sense. And a lot of what we'll talk about today, I'd love your thoughts as we talk through some of the different issues of how things would differ if you're in front of a jury or a judge when we talk through those. So, as a plaintiff in a trade secret misappropriation case, you not only have to prove misappropriation, but you need to be able to explain the trade secret or trade secrets to the defendant and to the fact finder, whether that be a jury, or a judge. So trade secrets are many times complex. They can be difficult for a layperson to understand. So how do you all go about explaining with specificity a trade secret at trial? And what tools do you use so that you can take something that's sometimes rather complex and make it easier for a fact finder to understand?
I think the first question is, from a plaintiff's perspective, is whether the trade secret is still intact when it comes time to put on the case. If the defendant's conduct has let the cat out of the bag, or whether there's still a protected interest in keeping the information confidential, will guide the strategy and how it's presented from the outset. Second, having someone at the client who can testify exactly how that trade secret information is used within the business and why it's valuable to the business will be an important first step in describing the information that's the subject of the dispute.
Yeah, look, Adam, I think you're right. Assessing your own witnesses, and particularly your own key business witness, is really important in terms of how you're going to present your case. It could influence the decision between judge and jury. It's certainly going to influence your decision as to how you develop your themes. In most trade secret cases, you are trying to simplify to make comprehensible, but not to simplify too much to seem like it's inconsequential. And so that's always a really tough balance as a matter of proof. And it's not something that lets you say, oh, going one way is jury and going other way is a judge. The particular individual characteristics of a single judge can lead you to different conclusions versus a jury than some other judge, just based on what you know. But I try to think about, what can I do in pictures? What can I do in graphs that are going to help beyond the mere words? There's this concept in advocacy, and certainly trial advocacy, that people will remember what you tell them, people will remember what you show them, but they're really going to remember what you show them and tell them. And so for me, trying to exhibit the technology, whatever it is, in a way that's graphic and memorable, as well as to explain what those representations mean, is really important. And you want a sense of, is this something a jury is going to comprehend, whether it's direct representations or analogies? That's how I'm thinking about the presentation of proofs and making that decision of, is this going to be better with a jury, or is this going to be better with a judge? I think particularly when you look at a judge, you also have to wonder, is this judge going to get everything? Or is there going to be too much for one person? Because, the jury has multiple people and they can help each other. So all those things go into the decisions, including, as Adam indicated, certainly how your witnesses are going to present.
Yeah, and I love the use of the word analogies, Jim, about how you can sort of take something complex like a trade secret and maybe for the jury use an analogy in the world that's easier for them to understand, so that it makes it easier for them to understand about why this trade secret was so important. And I think always, like, the key with as a lawyer is, it's like when we get to know an industry for the first time, we sort of like dumb it down for ourselves so we understand it better, but in a way that can show how complex these things can be in an easier way for juries to understand. So I like that as an example. But so safeguarding trade secrets at trial. I mean, the other challenge, and I think it happens obviously throughout the case, whether you're filing summary judgment or you're in hearings that might otherwise be public, but creates a new issue at trial, which is trying a trade secret case while also safeguarding the confidentiality of your trade secrets during court proceedings, because by definition, trade secrets must be kept confidential. And so what tips do you have about how to keep trade secrets confidential at trial?
Very important. Doesn't matter what jurisdiction you're in or what forum. You have to do pretrial conferences, including pretrial conferences in chambers or under a sealed record, to come up with some defined terms. And that is often helpful because if everybody agrees on the definition, then you may be able to stipulate to it, show it to witnesses in writing who have confidentiality obligations, and still have the testimony come out in a way that's appropriate, because courts don't want to seal the courtroom. They want to keep it open. That's their preference, and that is their default. So whatever you can do to minimize the notion that you are, doing that, the judges are going to appreciate. And sometimes it comes down to those formal things that I mentioned, like stipulations. Other times it comes down to things like, which way is the screen in the courtroom going to be pointed? Is it pointed in such a way that the people in the jury box and the people in the well can see it, but the people in the audience can't? All of those things, play into how you have to think about this. So, any trial is, somewhat like a theater production, and, blocking and staging become really important in technology or trade secret cases, in my opinion.
Additional evidence, like circumstantial evidence, might come into play where a defendant accused of misappropriating a trade secret is suddenly marketing a product or a line of technology that they weren't otherwise previously using. And if someone from the plaintiff can connect the dots of how that new product relies on a trade secret information, code, formula, technology, what have you, that can help bridge the gap without disclosing the full content of a trade secret.
Right. And I think that one of the things that we've talked about in the past, I think, and I think both of you may have touched on this before, which is the idea of sort of coming up with code words that, if, like you said, Jim, everyone sort of agrees to, and then everyone knows what that means. That maybe the jury has certain definitions that they only receive, and then they understand that when used throughout the trial, that's what they're getting at. But I think what both of you highlighted is how important it is sometimes to know what your courtroom looks like in advance. I think that's true for any trial, but especially when you're using technology, and then coming up with those agreement with the other side well in advance of that trial, if you can, because getting bogged down in those during trial makes things, all the more difficult when it's coming up in real time. So this is kind of a related question. So obviously the focus today is talking about trade secret cases, but you can obviously have cases that don't include trade secret misappropriation as a claim, but because of the nature of the case, a trade secret will still be something that needs to be discussed in part at trial. How do you deal with that from a proof perspective? Is that sort of similar to how you would handle it as we discussed before?
Yeah, I think it is similar to what I said, but I would add a couple of highlighted items to that. When you're in a true trade secret case, everybody's ready for these things and thinking about them, but they can sneak up on people, and particularly the court, if you are in a different case. So, for example, you may be in a Lanham Act false advertising case, and it may deal with substantiation proofs or the lack thereof with regard to the advertising claims. The substantiation may itself be a trade secret, or the process through which you validate those things can have, aspects of important proprietary information. And so one of the things you want to make sure of in those cases is that in your pretrial conference and your pretrial order, there's generally, both in state systems and certainly in all the federal courts that I've, had matters in, there's always kind of a miscellaneous category or some kind of place to highlight things that may not be expected or anything else the court should know. So you want to highlight, that there. You want to make sure the court understands that, this isn't a trade secret case, but when, this particular fact witness gets up, or this particular expert gets up, it's going to be trade secret like. And I think just anticipating that for and with the court and with your adversary is helpful, particularly if it's going to be a jury trial, because as I said earlier, courts don't want to, close themselves to the public and they don't want to waste jurors' times. And if you don't flag these issues as ones that, will come up during the trial, all of a sudden you may be sitting at a trial, have to grab a sidebar with the judge. And then because it's going to take some time to deal with this and figure out how to deal with it, they may have to send the jury to the jury room. And judges don't like to do that if it can be avoided. So, I think that's a way in those other cases, along with all the other stuff, to find terms and, which way you point the monitor and all that stuff, really makes a good deal of sense when you have those other cases like false advertising or, one of those things where these technical issues can come up.
I agree with everything Jim said. And one additional point is, to the extent possible, trying to cabin those trade secret issues and discussions together. So it's not something that has to keep interrupting the flow of the trial and popping up throughout the span. If it can be open and closed in one witness or one set of witness and dealt with in one fell swoop, that might be most efficient.
So let's talk about witnesses. Who are your typical witnesses or categories of witnesses in these type of cases?
So Adam mentioned a couple. Certainly you're going to have one or more principal, business witnesses. And in my experience in the trade secret realm, assuming you're, trying this case and there is a damages aspect, you're generally going to have several. So you're going to have somebody who's going to explain the trade secret and the technology. That could be one witness who talks about how it's protected as well as how it functions, but it could be two. You could have the person who talks about, what the trade secret is and why it's important, and somebody else who talks about the practices and procedures for keeping things secret and the policies and those things. You're also generally going to have some kind of fact witness who deals with the economics, whether those economics are to prove damages or those economics are to show the importance of this product to the company and why, there's going to be irreparable injury if the trade secret is compromised, while monetary damages themselves won't equate to irreparable harm. It informs the discussion. So the business witnesses to me are those, plus, if it's a case of kind of direct misappropriation, anybody who says, yeah, I saw him send the email, or I investigated the laptop and I saw what was downloaded or put into Google Docs. And that could be an internal asset or, somebody you bring in from the outside in terms of forensic examination. And then you're going to have experts, and you're going to have experts that kind of trail along the same line. This does look secret in the industry, or this is important, or this is different. And then you're going to have your economic experts who are going to say that, here's the projected income stream from this, and this is what damages would look like, or this is what a reasonable royalty would be. That's, to me, kind of a summary of the major categories of witnesses you're going to have in this type of case.
One particular type of expert witness that seems to be a bit of an emerging trend is expert witnesses testifying about the reasonable measures taken to protect the secrecy of trade secret information. A plaintiff or defendant, but in this instance, the plaintiff, using legal scholars, consultants, practitioners in their particular business sector, can be qualified as experts based on their knowledge and experience in the field, and can offer their opinion on the level of measures similar organizations or companies in the broader industry would take to protect that type of information, and testify in their opinion that reasonable measures were taken to ensure the secrecy or not of that particular information.
Yeah, and let me just add to that. I mean, I think the summary I gave was one of witnesses that could generally appear for both sides and maybe a little tilted towards the plaintiff side for enforcement. Certainly, if you're a defendant in one of these cases, you're not only potentially going to have an expert testify, as Adam just described, but you may have fact witnesses who say, we didn't steal this. We were developing our own stuff 3 years ago, 8 months ago, before this new employee came to us, whatever it is. And so, there'll be business witnesses in some sense, but really dealing with independent development or state of the art within the industry, and trying to suggest either that there's nothing particularly secret about what was being done here, or trying to intimate that somehow this secret was discovered independently or through reverse engineering or some other legitimate means rather than in some manner that, involved the inappropriate obtaining of the information from the plaintiff. So from the defense side, obviously you're looking for those kind of witnesses as well.
If you do have a jury trial, I want to discuss a few things that, you should take into consideration. So for jury selection, what key issues do you take into consideration when selecting those jurors for trade secret cases? So do you, for example, do you choose at least some jurors with technical expertise, assuming you have a pool of jurors that have that? And if so, do you have any concerns about jurors relying on someone like that too much, someone that has some of that technical expertise? And then do you otherwise just look for any other particular educational levels or other characteristics in jurors that are maybe specific to these cases?
Sure. Kate, like you said, we're left with the pool that we're given for the most part and have fairly limited ability to pick and choose who we're actually taking on to our jury, and might have a few opportunities to strike one or two or three maybe individual jurors with our challenges. And for those limited challenges, I'm looking for someone with a dead set bias against some form of restriction on competing conduct, where they might view any sort of employer or employee litigation as inherently unfair. Someone with bad experiences in their own past, with non-competes or non-solicitation agreements, who are going to look disfavorably on keeping information confidential.
Yeah, look, I mean, I think Adam raises some really good points there, but let me pick up, Kate, on the sort of parts of your question that related to, education or career choice or the like. I don't generally want what I'd call subject matter experts in the field. So if my technology has to do with a particular medical device that is used in cancer treatments, I don't want an oncologist, but I'm not going to rule out all physicians because I like adjacent knowledge. I'm also not going to want necessarily somebody on the jury who either themselves or had a close family member who was using these products or products very much like them. But if I could have somebody who understands medical technology or understands how to, deal with things, I do want that. I happen to personally like people who are high school or college teachers because it's not to me about the knowledge that they bring to the courtroom. It's more about the abilities they bring to the courtroom. And if they know how to transfer information and to explain things, I like that attribute in a juror. I just don't want them explaining things that haven't come out in court. I don't want them tapping into their own knowledge base. I really want them to perhaps explain to another juror what was said by witness number one or witness number two, or how to compare those two things. So I look for some of those things. Obviously, you're looking for people that, for one reason or another, you may think are sympathetic to your main witnesses or to yourself. I happen to, in most trials, really be more concerned with what I think the jurors will think about me as opposed to any particular witness, because I think that I'm going to be the one communicating with them the most. And so that's the balance, and you'll look for those things. But I like people who can process information as opposed to people who are bringing knowledge with them.
Yeah, exactly. That's such a good point. In a totally separate area, like employment law, for instance, there's always that risk we worry about. For example, when you have a senior sort of HR person on your jury and worrying about them sort of second guessing HR's decisions. So it's sort of same concept here. So talking about jury forms, what are issues that arise when preparing jury verdict forms, and then also your thoughts related to that, your thoughts on the pros and cons to a general versus special verdict forms?
Look, my general take on that, if I'm the plaintiff, I want to know whether we win and how much. I want to make it really easy, and I'm going to mount my case in that fashion. If I'm a defendant, I want them to have to answer separately for as many of the individual elements of the claim as possible, and I'm going to want them to break down the damages in as many ways as possible. Now, the defendant who wants the 100-question jury sheet and the plaintiff's lawyer who wants the 2-question verdict sheet always meet somewhere in the middle. And it's generally not in the middle. I mean, we're really not talking 2 versus 100. You're generally talking somewhere between 2 and 12, maybe. But, that's to me where the tendencies are. Maybe a plaintiff in a particularly egregious case, if you're mixing some business torts in, may want a 3rd question on punitive damages, but that's really my take.
A special verdict form with hopefully fewer than 100 questions will provide a useful roadmap as you're preparing your case in the weeks leading up to look at a number of possibly yes or no questions that are going to be handed to the jury at the end of your trial and can help guide your strategy preparing your case of how is the jury going to answer these plain English questions. And as a plaintiff, making sure that you've given enough evidence to convince your jury that they should be marking, yes, answering yes for each of those questions will help give you a useful roadmap as you gear up for trial.
So, last question as it relates to jury trial specifically. Do you have any views on jury consultants as they relate to trade secret cases specifically? And then what considerations go into determining whether you all use jury consultants, of course, assuming that the client will allow you to use them, because I know they're very expensive at times.
Lawyers love information and love having information. And so I would never reject a jury consultant if the client was willing to pay for it. I think it's useful to have that information. It doesn't mean that I always follow directly and without, counterpoints the advice of the jury consultants. But yeah, I would love to have them. I think they can be particularly valuable in technology cases on a couple of things. One is what kind of people may be most open to the kinds of arguments we need to be making. And the second is, are there any, and I think Adam mentioned this earlier, kind of unexplored or difficult to discern biases that a jury consultant can help us ferret out that relate to who our client is. And I don't mean particular witnesses or particular representatives of the client as much as, is there somebody on the jury who, for various reasons that a jury consultant may find out in background checks or other things, have a problem with a foreign corporation or a foreign corporation from a particular country? Those are kind of things that I think it's good to know and the jury consultants, more adeptly get at, particularly in this day of social media examination and those kind of things. And look, if depending on how complex your case is going to be and how long it's going to take, I've certainly had trials that were looked to be fairly large ones or long ones where, we knew that we were going to have a dedicated jury pool where you can get some of those pool rosters a little bit ahead of time from the clerk's office, give your jury consultants a couple extra days to look through some stuff. Love to have them. It's not a justified expense in every case, so we do without plenty of times, but it's good information if you can have it.
As Kate mentioned earlier, when we jump into a case, we need to become experts in a new industry or field and possibly dumb it down for ourselves as we learn it. And then we live with a case for months to years and develop a bit of an expertise as we're getting ready for trial. Speaking about it almost becomes second nature. Presenting to a room of new folks where these concepts, vocabulary are entirely new to them will give I think a particularly useful opportunity to make sure you're explaining it from the ground up so that the new jury can understand the topics. And jury consultants and maybe mock juries can hopefully ask those questions and identify any gaps that might be in your initial explanation. As far as the cost and that conversation with a client, in the era of Zoom, there's new opportunities for utilizing remote mock juries and jury consultant tools to do presentations to a room virtually of 10, 20 potential jurors for a couple of hours, get some feedback, ask some questions back and forth, and do a bit of more of a cost-effective version than having full-blown mock trial in person.
Yeah, that's a really great point, Adam. Much has changed in the last few years with that. So before we wrap up, any final words of wisdom from either of you regarding trying trade secret cases that we haven't talked about?
I think I'd start with just saying that I thought Adam's last point was really good in the sense that when you live with it, you forget how complex this may be or how long it took you to learn because you've been living with it for some time. So we started off at the beginning, like, how do you talk about these things and what are you focused on? Whatever got you through the beginning, go remind yourself and refresh it. Make sure that your original analogy still works, or if it doesn't, come up with a new one. But make sure that your presentation is going to be fresh in the sense that you're going to be able to do it, whether it's for judge or a jury, in an energetic way that sounds new and important and doesn't just sound like, been living with this case for a long time, this is now the next step. If these cases go to trial, it's because they're important and you want to make sure you're coming at them with some level of vigor. And so, don't just rely on the fact that you've become an expert. Demonstrate your present skill. This is now the playoffs. This isn't the last couple games of the regular season. And so you got to come at it with that speed and intensity that you might see when, the regular season's over and now you're in the playoffs. And so I think you just got to bring that energy, and part of that's preparing in the right way and refreshing everything you've done.
Exactly. And like Jim said earlier, being prepared to tell people and show people visually, video, graphs, pictures, to get your information across in a memorable and understandable way.
Well, thank you both for joining today, and a special thanks to our listeners. If you would like to subscribe to Spilling Secrets, please go to ebglaw.com/subscribe, and you can click the box for trade secrets and non-competes to find our Spilling Secrets podcast. Thanks again, everyone, for joining. Until our next episode, this is Kate Rigby signing off on behalf of the Spilling Secrets team.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.